All right, so welcome to today's live review for the exam that's going to be this weekend. Just a quick review of what is on the exam. So it is 25 multiple choice questions, covers chapter 7 and the supplemental insurance material. See the brain dump for a list of topics you should consider focusing your studies on. I did send that brain dump in an email yesterday, so hopefully everyone got it. You'll have 30 minutes to complete the exam, which should be plenty of time. Some of those questions are pretty straightforward. And the exam is taken through Respondus on As You Learn. So if you haven't had a chance to take a practice test with Respondus, if you've done any updates on your computer or anything, please make sure that you do that. I have heard that using Google Chromebooks has been a challenge for folks. So if you do have a Chromebook, you may want to consider using a different device. You are allowed to use an iPad if that's all you have as well. And then make sure you have my number handy in case you run into any issues. So what questions do you all have as you were looking over the material? We'll start with that, and then I'll jump into some hypotheticals. All right. So I'll come back to Parker's question when he gets a chance to type it in the chat. But in the meantime, we're going to approach these particular hypotheticals with this IRAC method that we worked on last time during the review. So think about what's the applicable law here. So that's the I. What's the issue? What's the legal issue that's being dealt with here? What's the applicable rule? What's the rule of law that's actually being dealt with? Here's where you kind of spell out that prima facie case, duty owed, duty breach, causation, damages for negligence, and some of those other definitional components. The application analysis, I think that's where a lot of folks got caught up in the last exam. So that's where we're going to spend most of our time today. How do you take the rule, apply it to the facts, and come out with an outcome? And then what should the decision be based off of that? All right, so we'll start with Kathleen, the hypothetical one that I sent you all. Kathleen, who's 17 years old, is at the mall. She goes into the store, slips an iPod under her jacket, and I guess my hypothetical's getting a bit dated because I don't even think they sell iPods like that anymore. Thinking that no one's noticed, she turns to leave the store. The store manager is watching her on security camera. As soon as she passes the cash register, the store security guard hits her over the head with a club and knocks her out. He drags her to a storage room in the back of the store. When she wakes up an hour later, the security guard holds up a knife, a pair of brass knuckles, and threatens to torture her if she doesn't confess to taking the iPod. After Kathleen gives the iPod back, the security guard tells her that he's going to leave her in the room with no food and water until she dies as punishment for her moral corruption. He puts a gun to her head and says that if she tries to leave, he will hurt her and her family as well. He then spits on her and leaves the door unlocked. 10 hours later, the store owner comes in and takes her to the police station. Sorry about that. So when we take a look at this, we're going to have to look at a lot of different things on this hypothetical. So anyone want to take a guess at some of the potential intentional torts that you see here? And what facts lead you there? All right, so in this particular case, I guess we could kind of go line by line and see what torts pop up here. So we'll skip these first few lines that give us the basic facts of what happened. And then we'll go, as soon as she passes the cash register, the security guard hits her over the head with the club and knocks her out. What tort is that? Probably battery. Okay, so that would be plaintiff, would be Kathleen, defendant would be the security guard, the tort would be battery. What would be the defense there? Maybe necessity, but I don't know how that would play out well. He might be able to say, he had to do it out of necessity to keep her from leaving the store. But I don't know that would really work well in his favor. He drags her to a storage room in the back of the store. Then she wakes up an hour later and he holds a knife and a pair of brass knuckles and threatens to torture her. There you go. There's your assault. If she doesn't confess to taking the iPod, the security guards, he's going to leave her in the room with no food or water. So obviously he's threatening her and keeping her in a confined space. So remember, a confined space, possibly false imprisonment there. He could argue, that he had some sort of right to keep her because she did steal this iPod, but where his argument falls apart is how long that he kept her. So 10 hours later. So hopefully you spotted, battery, assault, false imprisonment. You could even make a case for intentional infliction of emotional distress. I mean, this is kind of the extreme and outrageous conduct that we talk about in IIED. So that might be one as well. Questions about that one? All right. Number 2, 12-year-old girl playing catch with her friends with a baseball in the middle of a field of a grass park near the edge of the field. A woman sitting with her beach chair reading a book. The girl throws the ball, but it went too far, goes over the woman's head, goes over her friend's head and towards the woman. The woman didn't see the ball coming and it hit the straw hat that she was wearing, knocking it from her head. She wasn't touched by the ball, but she was startled when the ball hit her head, and so she fell from her chair and broke her arm. What would likely happen if the woman initiated a suit against the girl for damages? All right, let's walk through these facts and start to apply some of our laws. So I guess, are we looking at intentional torts or negligence? And I think we're probably looking at intentional torts still here. So if we walked down the path of intentional torts, we could argue some transferred intent. So if you remember me talking about transferred intent, that would be a good place to play with that there. And so you could argue, well, did she intend to have a battery or an assault? Then you kind of have to circle back to the very first element of a tort here. How can you have transferred intent when you really don't have clear intent for this 12-year-old girl? She didn't really have intent to take this ball and hit the other girl that was, that she was playing catch with, or her friends that she was playing catch with. If she was, trying to throw the ball at her friend's head because she was angry because of the way the play went, and it missed her friend and hit the woman, then we can argue transferred intent. But the facts here don't lead us to even suggest that there's even intent necessary for an intentional tort here. Any questions about that one? So the answer to this question is, what would likely happen if the woman initiated a suit against the girl? Well, the issue would be, would there be the first element of the intentional tort, intent? And if the unlikely event, in the event that they're unable to find intent, then the woman would not be able to recover. All right, hypothetical 3, a water pipe burst, flooding the Invidious Workplace Company utility room and tripping circuit breakers and on a panel in the room. Invidious contacts Jordan, a licensed electrician with 5 years experience, to check the damages and turn the breakers back on. Without testing for short circuit, which Jordan knows that she should do, she tries to switch on a breaker. She's electrocuted, disabled, but survives, and then turns around and sues Invidious for damage, alleging that they were negligent. So we could walk through, duty owed, duty breach, causation, and damages, and let's go ahead and do that. But this is really going to rest in some of the defenses. But I think when we look at a defense, sometimes the defense is in the prima facie case. So what was the duty that Invidious Workplace Company owed to Jordan coming onto their property to test breakers? But let her know that there was water, and the water pipe burst. I think that would be the duty owed. Was there a duty breach there? Well, probably not. Causation, we wouldn't have any issues there. So really, this is going to hinge on defenses. What did Jordan, a licensed electrician with 5 years, do? She turned without testing for the short circuits, which she should do, she tries to switch the breaker on. So she assumes a risk. She knows the risk, confronts it voluntarily, etc. So she has engaged in an assumption of risk. So even if she was able to prove they owed her an additional duty, she is really the one with the above average intelligence. Remember, I talked about that when we talked about duty owed even. And so she should have known better. Questions about that one? Great. The fourth hypothetical, Jean owns 5 acres of land in an area of single family homes on a mostly 1 acre plot. Her property contains her house and 3 outbuildings. Among the animals housed in the outbuildings are Kennel, a dog, and Lewis, a tiger. Mary, a neighbor, is jogging past Jean's property. We don't know to what degree she's jogging past Jean's property. Under what circumstances is Jean strictly liable if Kennel, the dog, bites Mary? And here we just kind of have to go back to, okay, is Kennel, the dog, an abnormally dangerous animal? What evidence do we have to support that? Is it, in some jurisdictions, particular breeds matter. Has Kennel bit people before? Was Kennel, tied up properly in accordance to city ordinances? Those are all factors that would play into whether or not Jean is liable for Mary's bite from Kennel. But as far as strict liability, we'd have to classify Kennel as an abnormally dangerous animal. So he'd have to be, one of those classified animals in the jurisdiction, or he would have had to have bitten someone before. So those are the circumstances in which Jean would be strictly liable for Kennel's bites. Under what circumstances is Jean strictly liable if Lewis bites Mary, Lewis the tiger? Well, back to the same scenario, only we would likely classify tigers as an abnormally dangerous animal, and in all circumstances, Jean would be strictly liable if Lewis bit Mary. Questions about that? All right. I wanted to talk a little bit about this Tessica Brown scenario because I think it plays in nicely with some of the conversations about product liability. So I want to first start off with kind of how this might play out, right? So Tessica, claims that this product did not properly warn against usage in her hair, and I don't know if that's the facts of her particular allegations, or if she ends up making allegations in that way. But this is kind of how we're going to walk through it. We'll say that that's the situation. Well, Gorilla Glue, the company, would probably turn to either their in-house counsel or whoever they hire as their attorneys, or they might just go straight to their insurance company because they may have a product liability insurance coverage in their commercial insurance policy. And so here we would see the duty to defend from the insurance company is really triggered by a suit. And the definition of a lawsuit or a suit is pretty broad. I mean, it can include mediation, arbitration, and some of those other areas of a lawsuit, demanding damages against the insured, against Gorilla Glue for bodily injury, property damage, or personal or advertising injury. If the damages being sought are clearly not covered by that CGL policy, then the insurer doesn't have a duty to defend. But in this case, it's pretty basic. It probably would be covered under here. So let's think about what exactly might she sue for? Well, she might sue for product liability for failing to properly warn or to properly label Gorilla Glue's warnings. So here's the warning, I think, that's on the back of Gorilla Glue. Bond skins instantly, eye and skin irritant, may produce allergic reaction. Do not swallow, don't get in your eyes, do not get on your skin or your clothing, do not breathe in your lungs, et cetera, et cetera. So the question really is here, did the company warn against something that was intended or foreseeable here? So what might be the defenses raised here? I think we're really going to see some, let's walk through our prima facie case. Okay, duty owed, duty breached, causation. Let's sit there. Is it foreseeable that that someone would use Gorilla Glue in their hair? I think that's a question for a jury. And so I don't know what the answer would be based on the cases presented. I think some of the earlier stories that I heard was that she thought it was the other Gorilla gel product that was out there. So maybe they did have an affirmative duty to say something. So that just might be something to think about. So that's where that one would go. I think I've seen some articles talk about, is this a repeat of the McDonald's hot coffee case? If you remember the McDonald's hot coffee case, there's a great documentary about it. But essentially, this lady goes through the drive-through of McDonald's, gets a hot coffee. It's a coffee, puts it between her legs. Somehow, the lid ends up not being properly fixed. Either she was putting something in it or something along those lines, and it spills all over her lap, and she ends up with third-degree burns. And so there was a lot of news articles that said, every time you get coffee, you should be able to sue if it spills on you. McDonald's actually had a reputation for making that coffee extremely hot, above industry standards. So in that particular case, there were a number of facts that I think played into why she was able to get get the judgment that she was able to get. This one, I don't know if we'll see the same thing apply. I think this is really going to be subject to how an attorney spins it, or the case that's made. I think Gorilla Glue, I was pretty confident that I knew that anytime it touched my skin, and can you make the same argument that your scalp is your skin, and that they properly warned. Companies don't have a duty to warn against every possibility, but just to raise awareness around foreseeable use. Somebody would use Gorilla Glue aerosol spray in there. Any questions about that? All right, that's all I have prepared for today. If there's any questions, I'll take those now. All right. Well, if not, good luck on the exam. Hopefully these hypotheticals helped you walk through and apply some of the concepts a little more. If you're looking for additional practice activities, I would strongly encourage you to go to the McGraw-Hill Connect under the optional activities. And if you give me a moment, I will show you exactly where those are. All right. So if you look here, this is kind of your student view that you have when you pull up McGraw-Hill, and you've got the Smart book, Learn Smart. You scroll all the way down to the bottom. There's this folder of optional assignments. And if you click down here, you'll see some related to primarily chapter 7 is what you're going to see. And they're labeled by kind of the name, so under torts. So if you're like, I'm still not really seeing the difference between proximate causation and the but-for test, and cause and fact, you may want to play with this causation and damages exercise. This is an applied scenario, and the way it works is you open it up and it gives you a rundown of some of the beginning facts, and essentially you pick an avatar and you start playing the game. It's kind of game, but it's basically a texting conversation that you have between a couple of people. And so you read through these, click on them, and then eventually you'll be prompted to make a decision on how you want to respond. And it's a good way to kind of practice and see whether or not you're understanding, how to properly respond to some of these issues. So they're getting ready to ask me a question. And so then I would select one and it will tell me, oh yeah, that's right, I remember hearing that. Or no, I think you got that one wrong. And at the end, you'll see a score that'll break down kind of how well you did on these different concepts. And it'll tell you kind of what areas you probably should consider studying some more. There's also practice quizzes and some other applied activities. And I see a message in the chat. Awesome. Well, you have a great day, and good luck on the exam.